Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I'm able to cover a vast, diverse range of matters. Matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please do get in touch. Two ways to get in touch. You can call on the landline number which appears at the bottom of the screen. Alternatively, a very popular way of getting in touch is to send us a message on that mobile number which also appears at the bottom of the screen. So if you send us a message on that mobile number, the message will be sent through to me live here in the studios and I will be able to address any questions, concerns that you've raised. Now, on this show, we get numerous questions on immigration law, which is fantastic. Please do continue to send your questions in. But in addition to immigration law, I can advise on other legal matters. Matters ranging from family law matters, criminal law matters, personal injury law matters. So if you've got concerns, questions regarding those issues, please do get in touch and I will give you some advice in relation to that. A couple of very minor points before we get going. On a live show, sometimes it's not possible to deal with very complex matters. Sometimes I need to look at documents before I can advise you properly. Now, if it's the case that your matter is quite complex, or I need to look at your documents in a lot of detail, then I will ask you to leave your number with the control room and I'll have that more thorough discussion with you off air. But please do get in touch and inshallah, I'll try and assist you in the best way that I can. Now, before we've come on the show today, we've had a number of questions coming in. I've tried to have a look at the questions very quickly before coming on air today. Let's have a look at some of the questions which have been coming in on that mobile number, which is there at the bottom of the screen. First question, immigration law question, always a popular topic. Question from our viewer is, my 2-year-old son was born in my home country, so obviously not born in the United Kingdom. Born when I had indefinite leave to remain in the United Kingdom. Can I apply for British passport for him straight away? If not, what is the process that I need to go through? Which application form do I need to complete? So the key thing here is that the son, who is 2 years old, was born outside the United Kingdom. At the time of the child's birth, the parent had indefinite leave to remain, so not a British passport. Now, that is one of the key issues here. If a child is born outside the United Kingdom, and if at the time of the child's birth, one of the parents, it can be mother, it can be father, if one of the parents has a British passport, then it's very likely that the child who's born abroad will be a British citizen. Now, there are some exceptions to that, and sometimes in practice you do come across those exceptions. One of the exceptions is the parent who has the British passport upon which we're relying. Maybe they were born abroad and they obtained British citizenship by descent. So there's some very limited cases where the general rule doesn't apply. But in general terms, and there are exceptions, in general terms, where one of the parents has a British passport, then the child, whether born in the United Kingdom or abroad, will normally be a British citizen. There are limited exceptions to that. I keep on emphasizing because I don't want to mislead our viewers who are listening in or watching the show today. But generally speaking, there's a good chance that the child born abroad will be British. Now, in this particular case, we have a problem because what we are told is that the parents aren't British citizens. They only have or only had indefinite leave to remain. Now, the problem with that is that if a child is then born abroad, the child will not be a British citizen. And that's the case even if the parents then later on acquire British citizenship. The child born abroad at the time when the parents only had indefinite leave to remain will mean that the child does not have British nationality at birth. Now, that is the position. So what do you then do? You have a child that's born abroad, the child is not a British citizen, then you would normally have to apply for a visa for the child. And normally what you would do is apply for a visa for the child along with the other parent who is abroad. So in normal circumstances, what you find is the wife is abroad, the mother of the child is abroad. And what you normally find is that the sponsor who's in the United Kingdom, who now has indefinite leave to remain, will sponsor mum and will sponsor the child, so sponsor the wife and the child. So it's done together. And in that situation, they would be able to join the parent who's here and who has indefinite leave to remain. Now, that does open up its own issues. In particular, it's known as an Appendix FM partner application. And in our previous shows, we've gone through the requirements which need to be fulfilled. For example, for the wife, the mother of the child, there is an English language requirement, there's a financial requirement, there's a requirement in relation to accommodation, etc. So, the whole set of requirements which need to be fulfilled, that would obviously have to be done. But in terms of sponsoring the child to come to the United Kingdom, normally what you would do is sponsor the child along with the child's mother, the wife normally of the person who is settled in the United Kingdom. So they would come together to the United Kingdom after meeting the requirements of the immigration rules. And once they're here, obviously with time, they obtain indefinite leave to remain and they start their journey, the immigration journey, which ultimately leads to British citizenship being granted as well. So that's basically how it works. Ultimately, it leads to British citizenship being granted. Now, can you quicken the process? No, not normally. What normally happens is when the wife, the mother of the child, is here in the United Kingdom and she qualifies for indefinite leave to remain after living in the United Kingdom for 5 years, that's when normally the child qualifies for indefinite leave to remain. And your question about nationality arises then at that stage when the wife, the mother of the child, applies for nationality after having obtained indefinite leave to remain. The child would apply for registration as a British citizen as well, along with the mother at that stage. So it's a slightly longer path for the child to citizenship, but obviously there is a process there which needs to be followed. And as you follow the process, it ultimately leads to the child obtaining British citizenship. So if we just step back a bit, in essence, the position is this, that at birth, the child will not be British, but there is a process that you go through from obtaining a visa for the child, normally along with the mother of the child, to the United Kingdom, which ultimately leads to indefinite leave and British citizenship. Now, there are certain circumstances in which it would be possible to sponsor the child to come to the United Kingdom without the mother, but there are those are normally exceptions. We don't, unfortunately, have sufficient information to give more precise advice. But in terms of the general process, that is what you do. Now, you also ask, which form is it that needs to be completed? Well, look, if we were applying for British citizenship for the child, the form would have been Form MN1, which you can obtain from the Home Office website. It's an online form that you can get to and you can complete. But we are not, as I've said, at that stage where we can apply for British nationality. We're at the stage where you will have to apply for the child for a visa to join you in the United Kingdom. So now, normally, that's a separate online form that needs to be completed for the child. And then once the child has obtained indefinite leave to remain with mum, at that stage, you would be able to apply for British citizenship. Now, the situation is completely different if one of the parents in the United Kingdom at the time of the child's birth had British citizenship, in which case the child would be automatically British. Generally, there is an exception to this, but generally speaking, the child would be a British citizen, and then it would be more straightforward and less costly, because at that stage, you wouldn't be applying for British nationality for the child, because generally speaking, the child is British. What you would be applying for would be a British passport, an overseas British passport. The process is similar. What you find when you look at the website is for certain countries, such as the countries in the Middle East, it's a much more simpler process, online process. Other countries, Pakistan, India, etc., they use the old paper form. But in the end, the process is the same. Normally, the child would be eligible to acquire a British passport, and you simply follow the process through for applying for a British passport. They do ask for quite a few documents. You submit those documents, and ultimately, whether it's in a month, whether it's in 8-9 months, you qualify for a British passport, and that's relatively straightforward. But in answer to your question, we're not, unfortunately, at that stage yet. We have a much more longer process to go through before we get to the stage of applying for a British passport for the child. So I hope that answers the question. Now, there are some exceptions to what I've explained. And if you do send us a follow-up question, I'm more than happy to take you through your particular circumstances in greater detail. But based on the question that you've put, that's the basic legal position. We're taking a short break. Inshallah, we'll be back in the next couple of minutes. I will see you then. Assalamu alaikum. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live, please ring on the landline number which appears at the bottom of the screen. Alternatively, a very popular way of getting in touch, and we've had numerous questions coming in already, is to send us a message on the mobile number which also appears at the bottom of the screen. So please do continue to send your questions in on that mobile number which is there. Questions will be fed through to me here live on air, and I'll be able to address your questions live on air. If after having looked at the question and the way I've answered it, if you've got follow-up questions, if you feed them through, I'll get it straight away, and I will be able to give you more specific advice or deal with any additional concerns that you have. Okay, let's look at the next few questions that have been coming in. Next question is regarding somebody who's been here on multiple visit visas. Our viewer says, I have an existing 10-year multiple visit visa. Is it possible to switch over to indefinite leave to remain? So, interesting question. Wanting to switch from a 10-year multiple visa to indefinite leave to remain. Is that possible or not? The short answer is that it's not possible. So multiple visit visas are simply visit visas which allow you to come and go from the United Kingdom as a visitor. Beyond that, in terms of trying to obtain some kind of permanent residence in the United Kingdom, that simply cannot happen with a visitor visa. Now, in terms of visit visas, what you have to remember is visit visas come with certain conditions, certain restrictions. So, for example, as you'll be aware, with a visit visa, you're not, even if it's a multiple visit visa which extends over 10 years, you're not meant to be staying in the United Kingdom for more than 6 months on a multiple long-term visa. If you come to the United Kingdom, the maximum you can stay without breaching immigration rules would be 6 months. If you were then to go back, and if you were to come back again very quickly afterwards and then spend more time in the United Kingdom as a visitor, even that could cause a problem. Because as a visitor, although the maximum you can stay on one visit is 6 months, you're still meant to be spending the vast majority of your time outside the UK. So you can't simply live here, go back for a few weeks, come back, and then stay here again on a visit visa. If you do that at the airport, if they realize what you're doing, they could cancel your visit visa on the basis that you're abusing the immigration rules. So what the point I'm making is that with a visit visa, there are certain conditions, certain restrictions, others you'll be familiar with. You can't work. If you want to register your marriage, you're not able to do that if you're simply in the UK on a normal visitor visa. So there are restrictions on that. And in terms of the biggest problem is this, and this is something that one is asked quite regularly in practice, you can't extend normally your visit visa in the United Kingdom. So if you manage to find work permit employment, you can't go into that. If you are married and you've joined your partner here in the United Kingdom and your partner's got British citizenship or indefinite leave to remain, or they might be under some other visa route, you can't extend your visa from a visit visa into that particular route based on your relationship. There isn't much you can do with a visit visa in that sense. Now, there are some things you can do, obviously, with a multiple visit visa. You can come and go. So these are obviously very helpful visas to have. It gives you a lot of flexibility in terms of coming and going from the United Kingdom. However, you won't normally be able to extend your visa in the United Kingdom. And certainly, even though you might have been coming to the United Kingdom quite regularly, you might have been spending 3-4 months a year in the United Kingdom. And if you've got a 10-year multiple visa, you might have been doing that over a 10-year period of time. So, you've built up your links with the United Kingdom. You've spent a lot of time in the United Kingdom. Even then, you can't apply for a longer period of leave in the United Kingdom. And certainly, what you can't do is apply for indefinite leave to remain based on your multiple visits to the United Kingdom with a multiple visa to come to the United Kingdom. What can you do? That's the negative. What can you do? Well, what you can do is legitimately, you can look at alternative routes which lead to longer term residence in the United Kingdom, which may lead to indefinite leave to remain in the United Kingdom. Absolutely permissible, absolutely fine by looking at alternatives to settling in the United Kingdom. And what alternatives come to mind? It could be, if you're single and want to get married, to somebody who is a British citizen or has indefinite leave to remain. That's one possibility to live in the United Kingdom on a longer term basis. You could live on a spouse visa. If you are lucky enough to have somebody who's prepared to sponsor you under the skilled worker scheme, the work permit scheme, you would be able to come and work for an organization here on a longer term visa. And ultimately, after 5 years, you would qualify under that route for indefinite leave to remain. So the point is, although your visitor visa may not be too helpful, it may not lead to the right to live in the United Kingdom on a longer term, you could use that opportunity that you've been given to come to the UK, develop your links here. You could use that to look at, to consider other routes which do actually lead to leave to remain in the United Kingdom or indefinite after a while leave to remain in the United Kingdom. So normally these are spouse visa route, the skilled worker work permit route, and at the moment you have a lot of foreign students coming to the United Kingdom as well to study. So that's another route that you can look at as well. So these are the routes that you can look at to come to the United Kingdom in order to live here on a longer term basis. But what you can't do is use just the visit visas to try and get a leave to remain in the United Kingdom. But I hope that helps. Now, another question. Visitor visa seems to be quite a popular topic today. Next question that's come in also relates to a visitor visa. The question is, the brother says, Assalamu alaikum, I have applied for a visit visa for my mother-in-law twice. Both occasions we've had it refused on the basis that she has no ties to her home country. Should I apply again? What should I do differently? Now, visit visas are notoriously difficult to obtain. I would say, in my experience, I would say 2/3 of visit visa applications are refused. At least 2/3 of visit visa applications are refused, if not slightly higher, around the 70% mark, but possibly. And the reason for that normally is that the Home Office isn't satisfied that, based on the circumstances of the applicant, that the applicant will return to their home country after the visit. So they're concerned that if the applicant is granted a visa, he or she will come to the United Kingdom and stay here and won't return back to their home country. Now, on what do they make that assessment? Obviously, the immigration officer doesn't know what's in somebody's mind. So, for example, somebody might come from quite poor circumstances, but they might have every intention to return to their home country after a short visit. So, might come from a poor background, but if they come to the United Kingdom as a visitor, they have every intention to return. So that's what's in their mind. An immigration officer can't obviously tell what's in somebody's mind. You might have somebody extremely well off, and they're thinking, you know what, once I get a visit visa to the United Kingdom, I'm not going to go back. I'll do something to try and stay here. Again, the immigration officer doesn't know what's in somebody's mind. So what do they look at? How do they make these assessments, which unfortunately results in the vast majority of applications being refused? Well, what they look at is the person's circumstances. Now, and they say, well, when we look at a person's circumstances, what we're looking at is a person's ties to their home country. Okay, well, what does that mean? What it really boils down to generally is them looking at a couple of factors. The main factor appears to be the applicant, the visitor, their financial, I do apologize, their financial circumstances, how well off they are. And their assessment normally is this: if a person is well off in their home country, there's sufficient ties there, they will go back. If they've got a job there, if they've got a business there, if they've got good income there, good savings there, they will go back. The majority of decisions are based on finances of the applicant. It does unfortunately mean that if somebody's not well off, even though they might have every intention to go back, they are less likely to have their application approved. Now, the immigration officer will look at other circumstances. Yeah, will look at whether they've got a partner there, whether they've got children there that they need to go back to, other similar circumstances. But the vast majority of cases, the focus is on a person's financial circumstances. The person's family circumstances appear to be more secondary. So that's the issue. The immigration officer obviously doesn't know what's in somebody's mind. They assess the application based on circumstances. And if you go one step further, what they're looking at really is somebody's financial circumstances, generally speaking. Now, there are certain things that you can do to make your application stronger, certain things that you need to avoid in order to not have your application refused. We're going to be taking a short break. Inshallah, after we come back from our break, we can have a look at those issues as to how you make these applications stronger. See you in a bit, inshallah. Assalamu alaikum. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, a very popular way of getting in touch is to send me a message on that mobile number which also appears at the bottom of the screen. So mobile number for messages, text questions, they will be fed through to me here live in the studio and I'll be able to address your questions live on air. Always a very popular way of getting in touch. So please do continue to send your questions in. Now, just before our break, we were looking at a question that had been sent in on visitor visas. And in particular, where I'd got to was looking at common problems which lead to visitor visas being refused. Now, as I said before, the main focus when an immigration officer looks at a visitor application is to look at the visitor, the applicant's financial circumstances. That's the main focus. And there, the first issue that arises, or the first thing that the immigration officer looks at, is the person's bank statements. Now, my personal view is that as a minimum, you should be submitting 6 months of bank statements of the visitor, ideally longer. And I say longer because if you've got a bank statement which spans 12 months or so, the immigration officer gets a better view of the person's financial circumstances than if it was only 3 months or 6 months. So the longer the statement period, I think the better it is for the immigration officer to assess the application. Now, what do they look at on the bank statement? Well, they're looking at the money coming in and then to a lesser extent, the money going out. So if as a visitor, as an applicant, you are saying that, you know what, my monthly income is equivalent to £700-800 a month. So what the immigration officer is doing is looking at the bank statement to see whether your bank statements reflect that or not. So if you're employed, is your money coming in from your employment into your bank account? If you're self-employed, is the money coming into your bank account consistent with the amount you claim is your profits? It's always difficult with self-employment to prove what prove convincingly what your income is. But nevertheless, the starting point is the bank statement. What's coming into your bank account? Is it consistent with what you're saying? Does it corroborate what you're saying in terms of your employment or self-employment? So, fine. You're showing the money coming in. The problem that arises in terms of money coming into the bank is if you've got other sums of money coming in, unexplained deposits where we don't know what it is that's coming, random deposits, the Home Office will most likely say that what you're trying to do is inflate your bank account, give an exaggerated picture of your financial circumstances, and that's likely to lead to your application being refused. Now, if you're submitting, let's say, 12 months of bank statements and you've got money coming in which is not consistent with your normal income, then I think what you do need to do is explain where that money's come from. If you don't explain it, you leave yourself open to the immigration officer simply saying you have unexplained deposits, and they will identify the unexplained deposits and say that given the nature of the deposits and the unexplained nature of the deposits, they cannot be satisfied that you have given an accurate picture of your financial circumstances. So straight away, you've given the Home Office the opportunity to refuse your application. Now, the other thing that the Home Office will look at is the money leaving your account. So if you've said, look, you know what, I've got £700-800 worth of equivalent income coming in, my expenses are only £100 a month. So I have loads of money to live on, and I will go back to my home country. I have a lot of money coming in, and I don't use that money up. But looking at the bank statements, it looks like your expenditure, your monthly living expenses are significantly more than what you've declared. That could be problematic as well. So they might say, well, on the application form, you're suggesting that you can live off £100 a month. When you look at your bank statements and your withdrawals, the payments going out, that would suggest that your expenditure is far greater. And again, the problem is you haven't sufficiently explained your financial circumstances. We go back to what I said before the break. The financial circumstances, your financial circumstances is what they look at to assess whether you will go back or not. Simple way to look at it is, if you're reasonably well off, they will assume you'll go back. If you're not reasonably well off, they will assume that you won't go back. And in particular, if your bank statements, the picture that you're trying to portray has gaps and there are issues, there are unexplained deposits, unexplained withdrawals, then they may well take the view that we cannot be satisfied that you have presented an accurate picture of your circumstances. So I always say, be careful about and spend a lot of time in relation to your finances. And I always say that. I think that's always the key. One of the other things that you could do, which people do sometimes miss out, is accurately explain your family links to your home country. So for example, if there's a couple, but only one of them will be coming to the United Kingdom, the other is staying behind, you need to explain all that and you need to document that as well. Because what you're trying to say is that obviously when I come to the United Kingdom as a visitor, I will go back because my partner is there, and I will go back obviously because I want to, I'll have to go back to my partner. I can't live here because my partner is abroad. So you need to look carefully at how you can document your family circumstances in your home country. You might have your partner there. You might have children who are dependent on you under the age of 18. So you might be able to demonstrate that, look, I have children to go back to. I can't live in the United Kingdom. I'm here for a short visit on my own, and it's not realistic for you to say I'm going to stay here because for example, my wife is abroad. My children who are young are abroad. I will have to go back to. So what you've done, you've presented, first of all, a very clear picture of your financial circumstances. And the second thing you've done is demonstrated that there are family reasons as to why you need to go back. So these are things that you can do to make your visitor application better. The other thing that you can do is that there may be other compelling reasons as to why you need to go back. So for example, it could be that you look after somebody who's unwell. A parent may be unwell and you're the primary carer, and that's why you can only come to the United Kingdom for a short period, and then you would need to go back because you have caring responsibilities. So there might be compelling reasons as to why you need to go back. So that's what you need to look at in order to demonstrate to the satisfaction of the immigration officer that, this is a genuine visitor application and that you will go back. But hope that answers your question. Okay, got another question coming in on spouse applications. Always a popular topic. And this particular question is regarding the financial requirement that needs to be satisfied when somebody is making a spouse application, and in particular, the issue about carers allowance. If somebody is in receipt of carers allowance, the question that's been put to us is, our sister says, just a quick question. If somebody applies with carers allowance, how do you satisfy the income requirement? Do you still have to show £18,600? Right. And we've had this question on our show numerous times before, but thank you very much for sending that question in. The basic position is that in a normal application, you need to show that your partner here in the UK, or the partner here in the UK, is earning £18,600. But there are limited circumstances where you don't need to do that. If the person here, the sponsor, is in receipt of carers allowance, is in receipt of disability benefits, such as DLA, PIP, etc., then they don't need to meet the 18,600 requirement. They can rely on their carers allowance, they can rely on their benefits, and in addition to that, if they've got part-time work, they can rely on that. So it's easier to meet the financial requirement. The financial requirement is not 18,600, it's much less. What the Home Office looks at is, have you got enough income to at least meet or exceed what you would get if you were in receipt of income support as a couple in the United Kingdom? So there's a calculation for what a couple in the United Kingdom would get in terms of income support. So that's what the Home Office is looking at. In addition to that, they're looking at whether you've got enough money to meet your rental commitments and council tax. But let me give you a very basic example. Somebody who lives in receipt of carers allowance, lives with parents, so no rent or mortgage to pay, council tax isn't in their name, no children. Simple case, sponsoring their wife to come to the United Kingdom. They're in receipt of carers allowance. From carers allowance, they get about £69 a week, just over that. In addition to that, they might get some income, some universal credit if they qualify. If not, they might have a job. But if their income, however it's made up, however it's combined with carers allowance, exceeds about £120 a week, that would be sufficient. So they could get carers allowance of £69 a week, do a job where they get £100 a week. That in itself is sufficient if you're just a couple in the United Kingdom, no rent to pay, no council tax to pay, and there are no children. So it does make it very, very easy to get a spouse visa if you're in receipt of carers allowance. Now, you posed a general question, so I've had to answer it in a slightly general way. If you've got more specifics that you want to send to me, please do that. And I will go into the specifics of your case. But in general terms, it is much easier to apply for a spouse visa where the sponsor, the person in the UK, is in receipt of carers allowance. It's much, much easier. But thank you very much for your question. We're taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number. And as always, a very popular way of getting in touch is to send us a message on the mobile number, which is there at the bottom of the screen. Another interesting question that's come in on carers allowance. I think one of our viewers might have been listening to the answer in relation to spouse applications and the carers allowance route, where it's easier to sponsor somebody to come to the United Kingdom. But another related question to do with carers allowance, and our viewer says, just a quick question, if you know the answer. Can someone apply for carers allowance if they don't have nationality yet? Like my sister-in-law who has just come from Pakistan. Now, okay, that's not strictly an immigration question. It's more to do with benefits and who is eligible for benefits. Now, the position basically is that at this stage, if she's come just recently from Pakistan, she won't have indefinite leave to remain. So she can't apply for benefits at this stage because with normal limited leave in the United Kingdom, there will be a restriction on her card which says you can't have recourse to public funds. So that's where the problem is. So once she gets indefinite leave, she can apply for carers allowance. So I think that's the issues. I'm just looking at what other follow-up questions there are. Now, when somebody comes to the United Kingdom, and I think this applies to the vast majority of visas, there are some exceptions, there are normally restrictions on their ability to apply for benefits. So a typical scenario, like what we have here, is our viewer is saying, sister-in-law has come to the United Kingdom just recently. So she will be here on a 2.5-year partner visa. And what you normally have on a 2.5-year partner visa is a restriction on being able to apply for benefits, whether it's universal credit, whether it's housing benefit, etc. Now, what that means, obviously, is that the person who's come from abroad can't qualify for benefits. Now, there's no restriction on their partner applying for benefits. It's only the person who's come from abroad who's here on a visa that can't apply for benefits because of the no recourse to public funds restriction. Okay. Now, two things could happen. Once they qualify for indefinite leave to remain, leaving nationality to one side, once they qualify for indefinite leave to remain, they would then have that restriction lifted. It doesn't apply anymore, and they can apply for benefits at that stage. The other thing that could happen is that if they apply for the no recourse to public funds, a restriction to be removed, then they would qualify at that stage. If the application is successful, they would qualify to have access to public funds at that stage. Now, when you apply for the no recourse public funds restriction to be removed, it's not a very straightforward process. The Home Office will assess the couple's financial circumstances, the money coming in, they'll assess their bank statements, the money going out, etc. And if they are of the view that yes, you do qualify for benefits because you're struggling, there's a test that they have, and if you fulfill that test, then yes, you will be given access to public funds. If you don't, then you won't be able to qualify for public funds. So normally when somebody comes to the United Kingdom, there is a restriction on claiming public funds. You can access public funds as soon as you get indefinite leave to remain, or if you ask the Home Office to remove that restriction. And the way you do that is you make an application, online application, and you explain your financial circumstances. Now, if it works and the restriction is lifted, then you will be eligible to apply for benefits straight away. The downside to that is that what the Home Office will do is move you to the 10-year route to settlement. So instead of the 5-year route to settlement, which is what spouses are normally on, you come to the United Kingdom, after 5 years, you become eligible for indefinite leave to remain. If you try and get the no recourse to public funds restriction lifted, and you are successful in getting that lifted, then you will be moved from the 5-year route into the 10-year route to settlement. So you do need to keep that in mind, that you would be moved to the 10-year route to settlement. So you need to keep that in mind. Now, so if you are struggling financially, then obviously you should make that application. But if you think you can get by, you do need to consider whether it's worth going into this route, because if you do go into the route, you're being moved onto the 10-year route to settlement. So that is where the problem is. But thank you very much for that question. Now, next question that's come in, it's relating to work permits, always a popular question. Surprised we've not had more questions on that. A work permit or skilled worker visa, as they are properly known by the Home Office. And the question that's been posed is, Assalamu alaikum, my nephew is currently in the United Kingdom on a student visa. Would my nephew be able to transfer to the skilled worker visa from their current visa? A very common question that we're asked is whether it is possible to transfer from a student visa to a work permit visa. I think the reason we're asked that, what the law used to be before, if we go back about 2 years, is that you could only transfer from a student visa to a work permit visa if you have graduated from the United Kingdom. So once you've successfully graduated, at that stage you are eligible to transfer from a student visa to the work permit visa. That used to be the case. Not anymore. Under the current rules, anybody who's here on a student visa, a normal student visa, would be eligible to transfer to the skilled worker visa. So what the Home Office has done is made the route, the entry route to the skilled worker visa much, much easier. So somebody could be here as a student, they could be here on a spouse visa, they could be here on some other business visa, except visitor visas. These other visas, longer term visas, are all visas that you could be currently in the UK on and move out to the skilled worker route. Now, that is the case at the moment. We don't know whether things will get tougher later on or not. Very difficult to tell. Immigration policy changes very quickly. But the position as it is at the moment is that, yes, you are able to transfer from a student visa to a skilled worker visa. Now, what do you need to be able to do that? Well, some people, unfortunately, are under the misapprehension that all you need is maybe an employer to write a letter for you confirming that, they want, you've got an offer of employment, they need you in the business, and that maybe would be sufficient. Well, that's not the case. With somebody from abroad wants to go into the skilled worker visa route, they need a sponsor to sponsor them. So they need a business to sponsor them, a business with a sponsor license. So it's not a case of simply getting an offer letter, however strong that offer letter is and however well that offer letter is backed up with documents. That's not enough. What you need is to be sponsored officially under the sponsor management system, because without that, you can't be sponsored to work in the United Kingdom. Now, it is quite a long process. If you are lucky enough to have a sponsored employer that is willing to sponsor you, they are willing to sponsor you, they are willing to issue a certificate of sponsorship to you that will allow you to make an application for a visa as a skilled worker in the United Kingdom. So that's the system. It can be done, but you need to be sponsored by a proper licensed sponsor, somebody with a Home Office license. They need to sponsor you to work in the United Kingdom. If they're willing to do that, then yes, it is possible. Now, one point I should mention here, and this is sometimes a slight problem area, is that the skilled worker route has its own specific requirements in relation to English, has its own requirements in relation to income, and it's quite a costly process as well. So you need to bear these factors in mind. English shouldn't normally be a problem for somebody who is in the United Kingdom on a student visa. It's just that there's a specific test that you might have to do before you're able to apply for the skilled worker visa. So bear that in mind. If you're running out of time, you quickly want to get into the skilled worker route, bear that in mind that you do need to pass a certain English test, and the test that you did abroad may not be sufficient. Also bear in mind is that when you're being sponsored, the business has to offer you a job with a certain level of salary. So basic minimum wage may not cut it. So bear that in mind when you speak to an employer with the hope that they will sponsor you. There's a certain salary that they will have to pay. And lastly, bear in mind that it's not a cheap process. Very easily, it could cost just in home office fees around £3,000-4,000 if you're in the United Kingdom, plus lawyers' fees in order to go into the skilled worker route. So it's not that easy to do that. So what I would suggest is that if that possibility is there, you do obtain advice from a lawyer who specializes in this area of law, who can guide you in terms of how you can go from your student visa to the skilled worker visa. But thank you very much for that question. Fortunately, that brings us to the end of the show. Inshallah, we'll be back next week. Until then, Assalamu alaikum.